Last year, our seminar was called 94% Solution because workers were losing 94% of the time at the commission. Nationally, the numbers aren't any better. Chuck DeVoli reports, one of our former speakers from Willig, that benefits being paid nationally are down 40% between 1992 and 2011. Michigan is bragging that the pure premium rate has dropped 28% over the last 4 years. We, as representatives of injured workers, we need to keep fighting back. This is an occasion for us to develop new strategies, new ideas to continue in that fight. We're going to hear from the best members of our field talk about how to deal with job search proofs, medical proofs, the new MAJ rules, attorney fees, how to earn them, how to deal with liens. We're going to hear ideas about how to bring other types of claims with using the EEOC and other employment statutes. This is a fight that is going on everywhere, and as some of you or many of you may know, that Florida's system has been gutted over the last 20 years, and the Florida attorneys down there, with the help of Willig, have actually been successful in having their workers' comp statute declared unconstitutional. It's just a district court opinion, but it's these kinds of strategies that can shake things up, because that is the sort of thing I think everyone would agree we need right now. Take a look at the Paget case from Florida. I include it in the materials. The ruling of the Paget case was it's based upon constitutional law. The 14th Amendment, if you remember back from law school, talks about due process, and there's this doctrine of substantive due process, which the workers' comp statutes has to meet. And in the case of New York Central Railroad versus White, the court held the workers' comp statute in that case constitutional because it provided moderate and definite compensation to every disabled worker. And it talks about if benefits become too insignificant, then the system can become unconstitutional. So that is still the law of the land. So as we think about what we're dealing with here, keep that in mind. That argument prevailed in Florida. Oklahoma is dealing with similar problems. Oklahoma has passed opt-out legislation where employers don't have to carry comp. What they can do is design ERISA-based plans to cover work injuries that provide a joke of benefits with ridiculous standards of disability, with decision makers handpicked by the employer. And that's what Oklahoma is dealing with right now. Wyoming is dealing with similar problems. I read on the Willig listserv that too has been, they've had some success in filing in tort now because of that. So these are some of the battles that are going on around the country, and we're not alone in this fight. And I encourage everyone to become a Willig member if they're not already a member. The Willig Convention was in Santa Barbara this year. Joel Alpert and I went out there, and we really encountered a lot of interesting ideas and amazing attorneys that are fighting these battles. The Willig Convention next year will be in Chicago, and I would hope many of you are able to attend. One speaker at that convention, which I want to bring to your attention, I was very impressed with him. I haven't had enough time to communicate more with them, but this is a guy named Michael Duff. He's a professor of law at Wyoming University, and Wyoming Law School, rather, and he was a Teamster steward that then went back to Harvard Law School, and he teaches comp. He's written a textbook on workers' comp. And what he's working out right now, and what his presentation at the Willig seminar was, about judicial independence, bias, and integrity in the comp system. And he had a lot of great ideas about how to ensure that we're getting fair decisions from impartial decision makers, and what our remedies can be if we're dealing with that problem. And if you look at the commission statistics, we're dealing with that problem. So take a look at his work. He's not here today. Maybe we'll try and get him next year. But there's a lot of good ideas out there, and I'm hoping that's why we're all here. We're going to get some great ideas about how we're going to fight this battle. And our first speaker that I want to introduce is Jennifer McManus. She's an employment attorney at Dibb & Fagan. Her practice is entirely devoted to representing employees She handles cases ranging from federal wage and hour claims, FMLA claims, state and federal discrimination, whistleblower claims, representing clients in severance agreement negotiations as well. Prior to working at Dibb & Fagan, Jennifer spent 8 years as a career law clerk for Judge Bernard Friedman in U.S. District Court. She also worked as an associate at Miller Canfield, where she quickly realized that she disliked billable hours representing faceless corporations and joined the right team. She attended Boston University School of Law. She's married to John McManus, a defense attorney, and they have 2 young sons. Without further ado, I'd like to introduce Jennifer. Let's give her a big round of applause.
Thank you. Good morning. So, as you know now, I'm not a workers' comp attorney. I admittedly do not have tremendous knowledge about workers' comp, but what I do have is I've come about with the realization that a lot of comp claims actually are employment claims as well. And over the past few years, I've come to realize that a lot of my cases actually are comp cases that did not go anywhere. And so a comp attorney then will contact me and say, hey, Jennifer, what else can we do for this person? And so the reason I'm here today is to talk to you about what else you can do for your client, even if your potential comp case might not be something that you can really bring for your client. What else is out there? And there are claims out there ranging from FMLA to ADA, Family Medical Leave Act, Americans with Disabilities Act, state equivalent of the Americans with Disabilities Act, which is the Persons with Disabilities Civil Rights Act. There's also potential civil rights claims out there that you can spot and send your client to the EEOC. For example, if your client was treated differently than other employees because of their disability or because of their comp claim. What if a white male with a comp claim was allowed to return to work or was given appropriate accommodations or so forth, and the female was not, for example? Do you have a gender discrimination claim out there along with your comp claim? So what I want to talk to you about is how to spot those issues and how to really give your client complete 360-degree representation. Even if your client does not have a comp claim, for example, they come to you and you say there really isn't anything there, what else can you do for that client to represent the client and bring a stream of revenue to your office? This presentation came about because of a few cases I've had over the past year that have been brought to our office from some members of this audience. One case was a woman who worked in a school district, and she fell in a parking lot, injured herself. A man sitting in the back row sent her to us. She fell in the parking lot, injured herself. She went to our friend and said, what can I do here? She had some medical bills, but she went back to work pretty quickly, so her comp claim didn't have tremendous value. Meanwhile, while he was talking to her, she got fired. And she thought she was fired because she had reported the district to the CDC for some health and safety violations. And so she was sent to our office with a potential whistleblower claim. So we took on the whistleblower claim, we filed it in state court, and we're taking the deposition of the man who decided to fire her, and I'm drilling him about the whistleblower claim, right? When did you learn about the claim that was filed with the CDC? What did you do about it? Isn't that why you fired her? He says, I didn't fire her because of her complaint to the CDC. I fired her because she was driving me crazy about her medical bills. Okay. Next day, we file an amended complaint, include a comp retaliation claim. The case settles a few weeks later. So it's all about picking up those issues that come about even when you're knee-deep in the representation already. It could happen months after you already take on the client. Certain things come up and you realize, bingo, there's another claim out there, there's 2 claims out there, there's other things we can do with this client and with this case. Similarly, we had a client that came to us for what he thought was a comp retaliation claim. He slipped and fell making coffee at his place of employment, and he filed a workers' comp claim. He was terminated shortly later. They're fighting the comp claim because making coffee isn't one of his regular job duties, right? So they're fighting the comp claim. they're saying, we didn't fire him because of his slip and fall. He's fallen before. We haven't fired him before. Well, then I'm doing discovery. I'm finding some things out. I'm thinking, okay, well, there's an FMLA claim here. Originally, I didn't think there was an FMLA claim, Family Medical Leave Act, because in order to be qualified for FMLA protection, you have to have been employed for a full year. He had been employed for 363 days. Okay, so we're doing discovery, though. We get some information about their leave policy. It turns out he had quite a few days available to him that he could have taken as sick leave or vacation leave or personal days to bridge those days to then qualify for FMLA. So we amend the complaint to add an FMLA claim after we get the discovery in and we can see what their policies are. Then we get additional discovery in, and I realize they terminated his health insurance retroactively. So he was terminated on January 31st, but when they terminated his health insurance, they made it retroactive to the day before his injury. So we go to a facilitation. I haven't yet brought up this potential ERISA claim, which is what it would have been. We get to the facilitation. I say, you have an ERISA claim on you now, too. And if we don't settle this, I'm amending the complaint again and adding an ERISA claim. And we settle it then. So you have to be aware of what other claims might turn up, even in the midst of your representation. Another type of situation that can arise is if a client comes to you and says, I have tremendous emotional disability, psychological disability, because of how my employer treated me. I know enough about comp now to know that you're not going to get very far with that in your field. But we can get very far with it in the employment field, because what we can then do is ask these questions. Did you ask for some accommodations for your disability, such as maybe to have a quiet room that you could go to when the anxiety gets to be too much? Were you mocked about it? Were you made fun of about it? Were you forced to work additional hours or additional shifts or have additional tasks put upon you to make it even harder for you? Then you might have an ADA claim, federal or state disability claim, okay, for a failure to accommodate or for discrimination. So we can sometimes, backdoor the same claim that they came to you for by filing it under our discrimination laws rather than under your comp provisions. So those are some other things to continue to think about when you're thinking about how to issue spot these cases. I had another client where she clearly had some disabilities, and her employers, her coworkers and so forth kept calling her crazy. To her face, just calling her a crazy woman. And she went to a comp attorney. The comp attorney said, and she became completely disabled. I mean, she broke down because of it. She went to a comp attorney. The comp attorney said, we don't have really great remedies here for you. And the comp attorney then sent her to us, and we did have great remedies. And we were able to take care of her. And the comp attorney was able to take care of her as well by referring her over and spotting this issue, realizing that while we don't have a comp remedy, there is something else out there that we can do for her. Now, the key to all of this is really knowing how to ask the right questions when you're doing your intake, and then how to pay attention to what's happening to your client while you're representing your client. And so you want to ask questions like, did you request or take a medical leave? Now, I understand that the comp laws do not protect your clients for actually having to take time off of work for their workplace injury, which to me just blows my mind, because you're injured on the job and then they can fire you for that injury because you haven't worked long enough to have FMLA protection. But if you have worked long enough to have FMLA protection, which is 1 year, and even if you've worked just under a year, still get this information, because like I said, sometimes we can bridge that time period to get your client to that 1 year period. If they have worked for at least 1 year for the employer, and they've worked at least 1,250 hours over the past 12 months, if the employer has at least 50 employees within a 75-mile radius, okay, and there are concepts of joint employers also. So sometimes they say, well, my boss only employs 30 people, but his sister has another 45 people down the road. Well, we'll look at that, or you look at that, and you say, well, what's going on here? Do they have the same accountant? Do they have the same bookkeeping? Do they have the same human resources? Do they have the same banking? They could be a joint employer, and you can meet the 75 employee minimum that way. So ask those questions, figure out what's going on. Ask them, did you request a medical leave? If they say yes and it was denied, do you have an FMLA claim? Possibly. If they say yes and I took one, and then when I came back to work they fired me, you have an FMLA case possibly as well. If they say yes and I took one and I came back to work, but they wouldn't give me my old position, they gave me a position on the docks in a very dangerous place and with a lower rate of pay, well, then you might have an FMLA case as well. So you ask those questions about the medical leave. Then you want to ask, did you request any accommodations for your disability? Because sometimes these people come to you with a comp claim, but they actually went back to work eventually, and once again, maybe the comp value isn't there for you. But did you ask for any accommodations? Did you say, I can come back to work, but I need to have a stool to sit on? Did you ask, I can come back to work, but I need to have a hearing, something to protect my ears? Did you ask, I can come back to work, but I can't work at the heavy machinery, I need a different position that maybe is a little bit quieter, or maybe they don't need to stand for as long, and so forth. And if they asked for those accommodations and the employer just said, no, can't do it, well, then you might have a disability claim on your hands, because the employer is required to interact with you, to talk to you about what the potential accommodations can be. They cannot just give a blanket no to a request for accommodations. Ask the employee, when you tried to come back to work, were you mocked? How were you treated? Were you given the least favorable assignments? Were you discriminated against for your disability? Or were you mocked? Were you treated poorly? Were you discriminated against for seeking workers' comp benefits? As most of you know, there's a comp retaliation provision in your statute. You can seek damages for any sort of workers' comp retaliation, which is not simply limited to termination. It also includes any sort of discrimination that you experience for seeking those benefits. You also want to ask, were you given a hard time for seeking comp benefits? Were you given a hard time for seeking FMLA leave? Were you given a hard time for seeking some accommodations? And if you were given a hard time, were you treated differently than other employees? And that's where maybe you can get into some of our civil rights laws, where you can say, were you treated differently than the non-minority employees? Were you treated differently than the younger employees? Were you treated differently than the male employees? And so you can sort of, you get this larger picture of what's going on. Maybe someone who had a comp claim just a month ago was treated perfectly fine, and your client was not. Why? What's the distinction here? And if you can draw that distinction here, you might have a case where you can send them to the EEOC, not necessarily on a disability discrimination, but maybe on a race or a gender or age or religious discrimination. Another question you want to ask is, how were you paid? And this is a question you all ask, I'm sure. How were you paid? But you want to ask more than that, because wage and hour claims right now are very big, and you can get tremendous recovery for your clients. Wage and hour claims include situations where your client was not paid overtime. 40 hours a week, as you all know, anything over 40 hours a week, they are entitled to time and a half. With certain exceptions, there's certain exemptions out there which are very intricate, and there's legal analysis and fighting about them all the time, but as a general rule, unless your client was some sort of an executive or administrator, if they're working over 40 hours a week, they're entitled to time and a half. If they're not getting time and a half, you might have a claim under the Fair Labor Standards Act. You want to ask them what kind of deductions were taken out of your paycheck. Certain deductions are inappropriate under the Fair Labor Standards Act, and they're entitled to reimbursement of those deductions, plus other penalties. And the Fair Labor Standards Act has a pretty strict attorney fee provision as well, as does the FMLA. And both the Fair Labor Standards Act and the FMLA have doubling provisions too, liquidated damage provisions. So these are all additional remedies that you can get for your client in addition to your regular comp remedies that you're here to talk about today. You want to ask about their health insurance. Do they potentially have an ERISA claim? When was their insurance terminated? I told you earlier that I had a client whose insurance was terminated retroactively to the day before his accident. He ended up with about $40,000 in medical bills because they terminated his health insurance retroactively. Then, as a defense, they claimed, well, he could have gotten COBRA and he turned it down. Well, he wasn't earning any money, so he couldn't afford COBRA. Once you see that the insurance is terminated retroactively, you want to take a close look at that, because you may have an ERISA claim, it's statutory, you file it in federal court, it's pretty open and shut, okay? There really aren't a lot of defenses to terminating someone's health insurance before their employment was terminated. So those are some additional things that you want to look at as well. What I can do now is I can actually go through some of these statutes step by step and tell you in more detail what the requirements of these statutes are. A lot of that information is in the handout. But when I was asked to give this presentation, one thing that was brought to my attention is a lot of you have encountered some of your own fact scenarios that you might want to talk about and talk about how we can issue spot within those scenarios. I don't know what the preference is, really.
If anybody has any particular fact scenarios they want to describe to her, feel free to do so. Joel?
Fact scenario, but I have a question for you, Jennifer.
Sure.
What are the damages you've recovered in FMLA case, and how do you decide whether you're going to accept it or not?
Okay.
What are the damages you've recovered for termination of health insurance or termination of employment?
Right. Okay, so in an FMLA case, your damages, traditionally in employment law cases as a whole, your damages are wage loss. Okay, so you have your wage loss from the date of termination to the date of mitigation. Now, your client may not fully mitigate, though, so then you go forward from there as well. What's the difference between what they were previously earning and what they're earning now? And how far forward can we go, realistically? The jury's not going to retire your client, right? So can you go forward 1 year? Can you go forward 3 years? Can you go forward 5 years? Well, part of that will depend on the age of your client. Did the employer already retire your client, right? I have a woman that came in yesterday. She's 63 years old. She was terminated the day after she came back from her FMLA leave. They essentially retired her. She's not going to find new employment making the money that she was making. So with that type of case, we are going to argue for 3 years where she planned on working until she was 66. She had already conveyed that to them previously. We are going to argue for 3 years of wage loss, plus the value of all other benefits that she received, which we generally value at approximately $10,000 a year. It's sort of a number that we use before we actually hire an economist and get knee-deep into it all. Under the FMLA, then, you are entitled to doubling. Under the FMLA, it's if it was a willful violation, okay? So if you can show that the company took willful steps to do whatever they did, such as, you find some emails within the company in your discovery that they were saying, we got to get rid of this woman, her medical leave is messing us up, things like that. Believe it or not, you turn up those emails, then you're entitled to doubling. Or if the company has already had 5 other lawsuits for FMLA violations, you argue that the doubling provision applies. The FMLA also has an attorney fee provision. Now, only less than 2% of cases ever actually go to trial, so the doubling and the attorney fees and that sort of thing are really leverage for any facilitation or negotiation you have with defense counsel down the road, because they're going to say, well, you'd only get that at trial, and that's the truth. So you do some back and forth that way. What's it worth? Well, an FMLA case, what does it take to take a case on? An FMLA case can be a little bit expensive because you're going to be getting the medical records, okay? Sometimes there's an argument about whether they were truly entitled to the FMLA leave, which, believe it or not, an employer can grant FMLA leave and then down the road say, well, they weren't really entitled to it anyway, and so we're not bound under the FMLA. So you may have to hire some experts to testify about whether they truly were entitled to that leave. So you're looking at somewhere between $5 to $10 grand in costs before you get to the point where either you're going to trial or facilitation. So does that answer your question a little bit?
Yeah.
Okay. Yeah?
You do electronic discovery of the defendant's emails yourself, or you hire a contractor, what does that
We do ESI, electronic discovery, electronically stored information. It depends, really. Now, sometimes, we'll wait and see what they turn over before we hire a contractor to do it for us. I had a case against Ford recently, an FMLA case. They turned over all sorts of great stuff, and it was pretty obvious to me they weren't holding back, because otherwise they wouldn't have turned over what they did. So we did not feel the need to hire a third party. There's other cases, though, where you do feel the need to hire a third party because you realize they're most likely not giving you everything that they have. And first we'll file a motion to compel and try to get the judge to order them to turn over more. And then if they're still fighting about it, then we'll have to get a third party involved.
Rick?
You talk about the interplay between workers' comp and FMLA. I think that's an area where a lot of us get tripped up.
Absolutely.
And when we redeem our workers' comp cases, the FMLA cases that automatically just go away.
Well, nothing automatically goes away, but it depends on when you redeem the workers' comp case, what the client signs. Are they waiving all other claims? An FMLA claim can be waived. A discrimination claim cannot to a certain extent, but an FMLA claim can be waived. And so it is a good idea probably just to make a phone call and share the fact scenario with an employment attorney and say, what else could I be doing here? Because if your client has worked for at least 12 months, or like I said, possibly less than 12 months if we can bridge it, if your client's been working full-time, and if it's a relatively large company, you very likely could have an FMLA case. And the FMLA is one of the only statutes that protects your client while they're on their medical leave from whatever injury they suffered in the workplace. Like I said before, I think that it's hard to believe that there aren't any other protections out there for workplace injuries, but if your client hasn't been working for a full year, they can terminate them the day after their injury, and they can just say, well, they weren't entitled to FMLA leave and we don't have to keep them on our rolls. But if they've been there for a full year, you definitely should explore that and see what other remedy might be available before you allow your client to waive all their other remedies. Yeah?
Can you run through the statute of limitations on some of these claims that you talked about?
Absolutely. And I actually, in the handout, I gave some basic statutes of limitations. It's not everything out there. But any sort of disability, discrimination, racial disability, gender, age, or religious, you have 300 days from the date of discrimination to file a charge with the Equal Employment Opportunity Commission. And that is very important because our state courts do not protect employees, okay? And so we want to get cases, and you want to get cases filed in federal court because our federal judges and our Sixth Circuit law is much more favorable to employees than our state court system is. So a prerequisite of filing a federal discrimination claim is to first file a charge of discrimination with the Equal Employment Opportunity Commission. It's a very simple process. I generally send my clients out to do it themselves. They go to the EEOC, they walk in during the walk-in hours, they say, I want to file a charge of discrimination. They sit down with an investigator, they tell their story, they're handed a charge, and the investigator starts investigating. After they get what's called a notice of right to sue, they have 90 days from that date to file their lawsuit. The first step we take when our client gets a notice of right to sue is we FOIA the EEOC file. And that way, you can actually see what the company told the EEOC in its defense. And you can see a lot of the documents that the company turned over to the EEOC in its defense. And it can really help you put together your complaint. So that's 300 days to file the charge, and the EEOC will only go back 300 days in its investigation. So you want to file it as soon as possible, especially if they had ongoing discrimination. Thank you. Okay, so I was just given the 1 minute mark. So 300 days and 90 days for federal claims. FMLA, 2 years. We have a 2-year statute of limitations. We have a 3-year statute of limitations if it was willful. Don't take that risk. File it within 2 years if you can. Equal Pay Act, we didn't talk about that, but 2 years and 3 years as well. Whistleblower claim, 90 days. If someone comes to you and says, I was injured on the job, and then I reported it to OSHA, and then they fired me, you have 90 days, okay? So you want to get them moving quickly. Michigan Persons with Disabilities Civil Rights Act, 3 years. And the Fair Labor Standards Act, which is the wage and hour claims, you have 2 years. You have 3 years if it's willful. So again, you don't want to wait for the willfulness. You want to argue willfulness when you actually file the complaint, so you can get 3 years worth of back wages, but you want to file your complaint within the 2-year period. And I think, is that my time? Okay. Well, thank you.
Thank you.